Welcome to Employment Law This Week. I'm George Whipple. The NLRB is continuing its labor-friendly trajectory with actions that are making it easier and faster for unions to obtain representation status, chipping away at other obstacles to union representation, limiting employer rights around work rules and employee handbooks, and more. This comes amid a spike in union activity, so great that observers have termed this the summer of strikes. But as Epstein, Becker, Green's Aaron Schaefer reminds us, these latest actions apply to more than just union shops.
Certainly, the NLRB is taking a much more aggressive stance toward non-union employers and union employers. Non-union employers will need to be cautious because the NLRB is expanding the traditional reach of the National Labor Relations Act to non-union employers. Employers that traditionally haven't concerned themselves with the NLRA are going to need to make sure that their policies and employment practices comply with the statute. For union employers, some of the rules have changed, and that will require a refresher and keeping up to date on these latest developments, because it may change how you interact with the union, the issues you need to bargain over, and how you reach a collective bargaining agreement.
With a Democratic majority in place on the board, which has been reinforced by the Senate's confirmation of Democrat Gwyn Wilcox for a second term last week, employers can expect the NLRB to continue on this path. Epstein, Becker, Green, Steve Swirsky tells us more about the current labor landscape.
We are sitting in a time where there are more favorable views about unions on the part of workers, and on the part particularly of young workers and highly educated workers, than has been the case for many years. The board decisions have created opportunities for unions, and I expect that unions will continue to press to take advantage of those opportunities. I think that you will continue to see pressure on employers, both by employees and by unions and by local and state governments. For example, just this past week, New York's governor signed a law prohibiting what are called, or what it refers to as, captive audience speeches, which really are a factor in union representation elections. I think the law is one of, I believe, 5 enacted by different states at this point. I think ultimately the courts will find that these laws are preempted by the National Labor Relations Act, but their passage really tells you that we're in an environment where there's a lot more interest in unions, there's a lot of activity on the part of unions, and a lot of activity and interest on the part of workers who might not have thought about representation in the past.
For more information on the recent actions from the NLRB, visit www.ebglaw.com/Labor Day. Before we go, a final note. Starting September 17th, all employers across New York State will be required to disclose the salary or the salary range in advertisements and postings for job opportunities. This new rule applies even to remote positions that report to a supervisor, office, or other work site in New York State. Thanks to Aaron and Steve, and thank you very much for watching. We'll see you next time.